welcome to everybody that's tuned into this session. I hope you get something out of it. We'll see. It's called Summons, Agendas and Minutes, and I will start with summons. It's quite interesting, actually, that from my perspective of giving advice to local councils generally, things come in bulk, in the sense that I haven't had any queries on summons or agendas for a number of months, but in the last month I've had several, and it's remarkable how people can take some particular aspect of local government law and start interpreting it in their own way, and it makes for an interesting reading. So what we will do is we will go back to basics and have a look and see exactly what is required. It hasn't changed very much. There are one or two aspects which people have raised, but we will see how it goes. The first is the summons. Now, I have lots of arguments with new clerks on this who say, no, we don't like the word summons. It's too peremptory. We don't like it. But in fact, it's a legal requirement that councillors are summoned to the meeting. So therefore, it should always say that councillors are summoned to a meeting wherever and wherever it is held. I've had several clerks say to me, oh, we really don't like it. So what we do is we send a summons to the council, and we send an invitation to members of the public. Well, if you like to make work, then that's something which is a possibility. But strictly speaking, you summons everybody to the meeting. When I go around the country, I always check on parish council notice board to see how meetings are being called. It's getting better. More people are summoning the council, but there are still a number of people that don't do it. It doesn't make the council meeting void, but it can make life somewhat difficult if you don't do it properly. The other question which is arising constantly these days is who signs the summons? We have clerks who are on sick leave or otherwise. Who signs it? Well, it is the person who is acting as the clerk at the time that the meeting is summoned. So if there is an assistant clerk and the chief clerk is not available, then it is the assistant clerk. It's only in very remote circumstances is it the RFO. I had a council the other day that said, oh, we always get the responsible financial officer to sign it. I'm not quite sure why, because they've got a clerk and a deputy clerk, but basically it is the clerk or the other proper officer of the council. It is in effect the person who undertakes the administration. Even if it is a locum clerk, it's the person that undertakes that task. The other point which comes up from time to time is distribution. Every councillor must have a copy of the summons. It can be sent by email, provided that the councillor agrees to accept it by email. I had a case the other day when somebody said, well, the councillor always says to me, you can send it by email, but I never read my emails. In that case, in my view, you have to make sure they have a physical copy, because otherwise they don't know what is going on in the meeting. So if they agree to accept it by email, it can be sent by email. Otherwise, it would have to be physical. And of course, it should still be put on any parish council notice board, as well as any website which the parish council operates. I use parish council to include town council and community councils, of course. So it can be put on their notice board. The important thing is that it is given as much publicity as possible, so that people in the community have an opportunity of attending. so that basically it is known about. What I've just said complies with the Local Government Act of 1972, which does lay down these provisions. And as I say, the meeting won't be void without them, but there could be some difficulties if controversial decisions are taken. So just to recap very quickly, summonsed, signed by the clerk or proper officer, and distributed. Now, the next item we have are agendas. And here we come into some very interesting questions. It must form part of the summons which calls the meeting. So therefore, the summons is for the meeting to discuss the following items which are on the agenda. As you know, it must be sent out at least 3 working days before the meeting. We've had a query recently about whether an agenda can be withdrawn and replaced, even if the agenda was published prior to the statutory limit. Now, there is an argument about this. Our view is that once an agenda has been put out and publicised, then it cannot be withdrawn. Now, I know some of you don't agree with that, but we think that having regard to the terms of the Act and as regards the fact that councillors must know the items which they are to discuss within the agenda, you can't have more than one agenda floating around. If you don't publicise the agenda completely, then it might be a position, but generally speaking, we think that once the agenda is published and is distributed, that is the agenda for the meeting, even if you've forgotten something, which is what happens from time to time. It must specify the business which is to be transacted. It doesn't have to be spelt out in words of half a syllable, but it must include sufficient information that those persons reading it know that it is to be discussed. This is particularly important not only for councillors, but for members of the public, so that they know that a particular subject will discuss something which may be close to their hearts or which would otherwise be of importance to them. So you can't have an item which is very vague, other than in respect of items which you may do under confidential sessions, which we will come on to in a minute. The agenda is basically the responsibility of the clerk. The agenda is, if councillors, 2 or more councillors, wish to call a special meeting to discuss a particular subject, then they have to put what they wish to discuss at that meeting on the agenda. That's the only time when councillors can dictate what goes on the agenda. Now, if you are a clerk, you will normally have regard to what is required, and you will discuss it the same with the chairman, who will have some idea of what needs to be discussed. There's very little point in deliberately excluding something which everybody is hopping up and down about, because if you don't discuss it at the meeting, then the councillors who are hopping up and down about it can call a special meeting for discussion. So you do have to have regard to what other people want, but nobody can dictate what goes on the agenda. We have cases where councillors say to the clerk, you must put this on, that on, or whatever it is. Strictly speaking, it is not necessary to do so. The first item on the agenda, other than in respect of the annual parish meeting, is usually apologies for absence. Now, this does give rise to difficulties because the law requires that reasons for absence are given. And if they are not given and accepted at the meeting, then the 6 months rule will start to apply. And if the councillor does not attend a council meeting or a meeting which he represents the council for a period of 6 months, they are automatically disqualified from acting as a councillor. However, a lot of councillors don't like the fact that they're going on holiday to be recorded on the minutes, as they feel it's an open invitation to people to come along and break into their house or burgle it or whatever is necessary. It's not necessarily what we normally say, that in these circumstances the reasons are not specifically stated, but it is stated that the reason was accepted by the council. Some councils have very elaborate coded systems for this. The important thing is that apologies for absence are talked about, accepted, to avoid the 6-month rule applying. So as long as there is some record of this, that is the important thing, because the other aspect of this, which is sometimes forgotten, is that if the 6-month rule does apply, then it's an automatic disqualification at the end of the 6 months. It's not a question of the council saying, oh, you are no longer a council. Automatically, you are excluded at the end of the 6-month period. You are only not excluded if you attend a meeting, or a meeting which is organised by the council, or are authorised to represent the council at a meeting of an external body. So if there's a meeting of a local group and the councillor goes along as a councillor, then the 6-month period would not apply. If an item is not on the agenda, you cannot lawfully make a decision on it. That's why you can't have items such as any other business. A lot of agendas that I see as I travel around still have any other business, but all that can be is a general report. You cannot take a decision on anything which is brought up on that under that heading. The only agenda items can be subject to a decision. You can have reports which are made, but as a result of that, a decision cannot be made unless the item is on the agenda. So if a councillor makes a report which says that the hedge at so-and-so recreation ground needs cutting, the council cannot immediately resolve to have it cut. Assuming they need that resolution, they cannot do so because it's not on the agenda. It's not an authorised expenditure. And as I say, these are reports only from working parties or whatever it is. If there is a report from a working party which requires the council to take a decision, then the item must appear on the agenda. As far as items are concerned which are to be taken in confidential session is concerned, these should also appear on the agenda, but should also appear on the basis that they are going to be discussed in confidential session. Now, this means that this will be more vague than will be the case for other items. So it will say to discuss a staffing matter, to discuss a code of conduct matter, to discuss something else. It will be much more vague as far as the agenda is concerned. But again, it will show that to a councillor that an item of that nature will be discussed. so that they've got some idea of what to do, where it's going. So that's your agenda. Now, just a few more points on an agenda, because we are coming up in some areas to elections. Now, the rules are quite clear as far as information about elections are concerned, in that it is not permitted to take any decisions or have discussions which basically favour one candidate or another. I had a horrific case last year when a parish council newsletter said that at the forthcoming principal council elections, you should vote for A, B, and C because they support the parish council. They were somewhat surprised to discover that this was in fact an illegal practice. So basically, in a period prior to an election, the council needs to be very careful about what it discusses. It can do routine business, but should not do anything which is controversial or which might lead to anybody to decide whether in fact they are favouring one candidate or one party or whatever against the other. So routine business is fine, but you've got to be careful about other things as well. We had a case recently of discussions at the parish council being used as publicity for a party which is standing in the election. You do have to be careful about this. There is a code of recommended practice as far as this is concerned, and the important thing is not to publish any material which is in whole or part designed to affect public support for any particular aspect of politics or any candidate. This also does sometimes have to be rather carefully looked at if you have events which, like mayors' balls and all the rest of it, that may have to be considered as to whether that comes within that category. So at an election time, do be careful about what goes on agendas. Turning to minutes, minutes are a formal record of the proceedings. They are not a verbatim report of what was discussed. I see very, very involved minutes, which are not what is required. All is really required in a formal minute is the decision which was made by the council on a formal resolution. Why? Because once that is done and is signed, then it's admissible in court proceedings as evidence of the event and the decision. Note that I say signed. It is the responsibility of the clerk to ensure that the minutes of the previous meeting are in fact signed. Now, if they are not signed, that can be difficult. I had a query yesterday when a clerk had discovered that there were whole sheaves of minutes which had not been signed, but which the subsequent meeting had stated that the minutes had been approved and signed. The thing that you can't do is sign them in retrospect. In that case, we would have to rely on the minutes as being signed, as being approved. We can't have them re-signed, but it is important that they are signed. Once they are signed, they are the formal record of the meeting. Now, this does give rise to another query which I had recently, when an ex-councillor required his name to be removed from all council literature, including the minutes of previous meetings. And the answer to this is it cannot be done. Once a record of who has attended the meeting is in the minutes. That is the minutes. So you can't remove it. You're stuck with it. So, as I say, it's a formal record of who was there, who made the decisions, and other matters as well. Now, it's not necessary to say who voted for what, unless there is a specific resolution for a recorded vote. But generally speaking, it is sufficient in the minutes to note that the resolution was passed. Originally, minutes were kept in bound volumes and handwritten. And I was asked recently by a council whether it was still necessary to have handwritten minutes. Apparently, their council had some years ago bought a whole load of leather-bound volumes, and there was still a number which needed to be filled up. The true answer is no. You don't need to handwrite them in the book, but the important thing is that if you keep them in any other form, they are kept in a form where they are numbered or they cannot be changed. In other words, people can't slip in an extra resolution or change the page of the minutes. And if you think that never happens, I can tell you that it does. So you have got a situation where you need to ensure either the minutes are numbered consecutively or the pages or something to ensure that they can't be changed. At the moment, purely computer records are not sufficient. It will happen at some stage, but at the moment, keeping them purely by computer is not considered sufficient. It's old-fashioned, but we all know that computer records can be wiped quite easily. As I say, you can't alter minutes after they've been signed and approved. And strictly speaking, any alteration to minutes at a subsequent meeting should only be for corrections, not for great debates about what the minutes are. We've had a number of cases recently where councillors and or members of the public have required the minutes to be altered and put into various items put into it. The answer is that is not permitted. The minutes are the responsibility of the proper officer. They don't have to take the minutes. You can have a minute secretary or otherwise, but they are responsible for the minutes of the meeting. Minutes of the annual parish, the minutes of the annual parish council meeting should be signed at the next meeting and should not be retained for the next meeting, which may not be for a long period of time. So the minutes, as I say, are the record. They are the legal requirement. They are the minutes of the meeting, cannot be changed, and should be as concise as possible. If there is an objection to the minutes, it is as well that it's raised as soon as the draft minutes are published. These days, draft minutes are usually published and put on the website before they are approved, so that people know what the previous items were and that they can read them as far as that's concerned. So, don't necessarily wait for them to be approved by putting them on the website, but put the draft minutes on the website. And again, don't necessarily wholly change them in wholesale if people start squawking about whether those minutes are correct or otherwise. You need to be quite firm on this, provided that they are an adequate record of the meeting. That is what is needed.